Hi, it's Claire back again with Putting the World to Rights, and this time I'm going to return to a subject I've talked a bit about before, which is AI. Um, I've been talking a lot to people recently about the kinds of AI licensing they're doing and some of the challenges that they're coming across. And anyone who knows me well will not be surprised that I'm returning to this particular topic, which is all about your rights data. And the reason that I want to talk about rights data, and in fact, this time about acquired rights data, is because, as with all licensing, it is absolutely pivotal to understand the rights that you have acquired in the content that you want to license before you can embark on any kind of licensing. And that really is rule 101 of rights selling. But it seems that with every new kind of rights opportunity that emerges, we sort of have to relearn that a bit, especially, in the world of AI licensing, where actually we're licensing multiple properties all at once to a particular customer. Trying to do anything en masse is difficult because often the publishing industry finds itself still a little bit analog when it comes to recording rights information. So it's another plea really to us as an industry to really get our rights houses in order. Think about not just what rights you've acquired in the book, but in all the constituent parts that might make that up. So if you've got forewords written by different authors, if you've got illustrators, if you've got third-party content that you've licensed under permission, all of those need to be factored in. So obviously one thing to be really aware of is that in any kind of licensing, you've got to be mindful of what other licenses you've already entered into, and whilst the agreements that you enter into with AI companies might be on a non-exclusive basis, that doesn't mean that there aren't existing exclusive licenses that would prevent you from then licensing that content, even non-exclusively, to somewhere else. So I'm thinking about things like exclusive translation rights deals that you might have granted. Obviously, if then you're licensing an AI company who could produce content in different languages, that potentially will cut across what you might have agreed with your translation rights customers. It obviously depends in each case on the specifics of the licensing agreements that you've both entered into and the ones that you hope to enter into. And as we know, rights people are always obsessed with contracts language and making sure that all those T's are crossed and I's are dotted. So it's just a plea in general, perhaps for you to share with people who don't have that rights brain always at work, thinking about exclusive, non-exclusive, specific rights, checking rights acquired versus rights licensed, all those things that we do every day. Share this if it's useful with colleagues in other teams, because I think it's not always straightforward if you don't work in rights regularly. So, although AI is something that's rapidly changing all the time, I take some crumb of comfort in the fact that actually rights and licensing doesn't change very much. It all comes back to making sure that we understand the rights that we've acquired and the rights that we're going to license.